Hey everyone, welcome back. Today we're diving deep into something that's, well, super relevant for anyone creating educational content.
Oh, yeah.
Copyright.
Big one.
It is. And get this.
Yeah.
Our source material today
Hi.
comes from a French legal resource
Oh, love that.
called Ganakel. I don't know about you,
Okay.
but I always find it fascinating to get an international perspective.
It's a smart move, actually.
Yeah.
Copyright laws can be, well, they can be tricky.
Right.
And seeing how another country approaches it, I don't know, it can really broaden your understanding.
I agree.
Plus, and this is important for anyone listening, in today's digital world, your content, think about it, it can easily cross borders. So knowing the global implications is key.
Exactly. So let's jump right in.
Okay.
Ganakel starts by defining intellectual property.
Okay.
And I have to admit, before I read this, I always thought it was just a fancy term for patents.
Uh-huh.
Turns out it's way broader than that.
It really is. Think of it this way. Intellectual property protects the creations of your mind, so to speak.
Okay.
It could be anything from, like, that catchy jingle you wrote for your online course
Right.
to a groundbreaking new teaching methodology you developed.
So unlike a physical object, intellectual property is all about the intangible.
Yes.
It's expression of an idea.
Exactly. And that's where things get interesting, especially for educators. If you create, like, a brilliant lesson plan, someone could easily copy it and share it without your permission.
That's scary.
It is.
So how do we protect ourselves? Ganakel goes into detail about copyright transfer agreements.
Uh-huh.
And honestly, it kind of made my palms sweat a little.
Really?
It's like, what are we really signing away
Right.
when we agree to those terms?
It's a valid concern. I've seen educators get burned because they didn't fully understand the implications of what they were signing.
Wow.
Let's break down some of the key terms, okay? Cession of rights basically means you're giving someone else the right to exploit your work, but in specific ways.
Okay, so let's say I create an awesome online course
Okay.
and a big educational platform wants to buy it.
Yeah.
Ceding my rights means I'm giving them permission to, what, sell it on their website?
Potentially, yes. But, and here's the crucial part, you need to be crystal clear about which rights you're ceding.
Oh, okay.
Is it just the right to reproduce the course? Can they adapt it, translate it into other languages? All of that needs to be spelled out in the contract.
Got it. No vague, all rights reserved kind of deals.
Exactly.
Speaking of contracts,
Yeah.
Ganakel really emphasizes that a written contract is a must.
Oh, for sure.
They even share an anecdote about a photographer who thought an email exchange was enough
Oh, no.
and ended up in a legal nightmare.
Oof. Yeah, that's a classic example of what not to do. A written contract protects both parties involved.
Okay.
It provides clarity and prevents misunderstandings that can lead to, costly disputes down the line.
So let's say I'm ready to put pen to paper.
Okay.
What are the essential elements that need to be in this contract? Ganakel has a whole checklist, which seems super helpful.
They do, and it's a good one.
Yeah.
First up, you need a super clear description of what rights are being ceded. We're talking reproduction, adaptation, distribution, the whole shebang.
Got it.
No room for ambiguity here.
And I'm guessing time limits and geographical scope are crucial too.
Absolutely.
Like, I wouldn't want to sign away the rights to my course forever
Right.
and for the entire planet. Right.
Exactly. A good contract will specify exactly how long the agreement lasts
Right.
and where it applies.
Okay.
You might agree to, like, a 5-year deal for online distribution in North America, for example.
Okay. That makes sense.
Makes sense.
What about the financial terms?
Yeah, important.
Is it a one-time payment? Royalties. Spill the tea.
Right. The contract needs to clearly state how you'll be compensated. Whether it's a flat fee, a percentage of the profits, or some other arrangement, it all needs to be spelled out in black and white.
I'm already feeling more empowered just knowing what to look out for.
Good.
But Ganakel doesn't stop there.
Nope.
They also outline 5 key points for a rock-solid contract that protects both the creator, the buyer.
That's where it gets really interesting.
Oh.
Let's unpack those 5 points because they can make or break a deal, especially for educators who might not be familiar with the legal ins and outs.
Let's do it. What's the first point on Ganakel's list for a rock-solid contract?
Well, the first point is all about clarity and transparency.
Okay.
The contract needs to clearly identify the specific rights involved.
Okay.
What exactly is the buyer allowed to do with your work and what's off limits?
So it's about setting clear boundaries from the get-go to avoid any surprises or disagreements down the road.
Precisely. Think of it like a fence around your creative property, you know?
Uh-huh.
The contract defines those boundaries. For example, if you're selling an online course, you might want to specify whether the buyer can edit the content or if they have to use it as is.
Makes perfect sense. What's the next point on Ganakel's list?
The second point is all about time and space. Literally.
Okay.
The contract needs to specify the time limit and geographic scope of the agreement.
Right. No forever and everywhere deals unless that's truly what you intend.
Yeah.
So if I'm licensing my lesson plans to a school district, I could say this agreement is valid for 3 years and only applies to schools within this specific district.
Exactly.
Okay.
Clear and concise.
Yeah.
Now, the third point is crucial, especially for educators who are often working on tight budgets.
Yeah.
It's all about outlining the payment terms.
Okay, so we're talking about the nitty-gritty of how much, how often,
Yes.
and how those payments will be made.
You got it. Whether it's a flat fee, a percentage of sales, or a combination of both, it all needs to be spelled out.
Right.
No room for ambiguity here.
And I'm assuming point number 4 dives into the specifics of how the buyer can actually use the work.
You're on a roll. That's exactly right.
All right.
This section should clearly define how the buyer can use the work. Can they modify it, distribute it to others, translate it into different languages?
So if I'm creating a series of educational videos, I might specify that the buyer can use them in their online courses, but not re-edit them.
Yeah.
Or create derivative works.
Precisely. It's all about maintaining control over your creative vision, even after you've transferred some rights.
This is all making so much sense now. And I'm guessing the 5th and final point is all about making sure everything is legit and above board.
You nailed it. The 5th point is all about ensuring that the creator can actually prove they own the rights they're selling.
Okay.
This is where things like documentation and timestamping come into play.
So it's kind of like showing your receipts, proving that you have the right to sell what you're selling.
Exactly. It protects both parties by ensuring that the rights being transferred are legitimate and enforceable.
Wow. We've already covered a lot of ground, and it's clear that these contracts are serious business. But what about situations where things aren't so clear-cut? Ganakel also talks about common traps to avoid.
Oh, yeah.
And they use some pretty clever analogies to make their point.
They do. And I think it's a smart approach because sometimes humor can help make these legal concepts more digestible.
Absolutely. So what are some of the biggest red flags educators should watch out for when dealing with copyright agreements?
Well, the first one is pretty obvious, but it's worth repeating.
Okay.
Never, ever rely on a verbal agreement or a handshake deal.
Yeah.
Get everything in writing.
Yeah, that seems like a no-brainer, but you'd be surprised how many people try to cut corners
Right.
and end up regretting it later.
Right. And almost as bad as not having a contract at all is having one that's too vague.
Oh, okay.
Ganakel warns against using broad language like all rights.
Right.
Because it leaves too much room for interpretation.
Be specific, people. Outline exactly which rights are being granted and under what conditions.
Exactly. And don't forget to specify the time limit.
Oh.
Does the deal expire after a certain period, or does it go on forever?
Okay, those are some excellent points to keep in mind. But what happens if, despite our best efforts, things still go wrong? What if there's a disagreement about the terms of the contract? Ganakel has a section on keeping things copacetic, preventing and resolving disputes.
Yes.
And I'm curious to hear your take on it.
That's a great question.
Yeah.
And it's something everyone should think about before signing any agreement.
Great.
Let's dig into that in part 2.
Okay.
After a quick break.
Sounds good.
Yeah.
Welcome back, everyone. Before the break, we were talking about contracts and how to avoid some of the pitfalls.
Right, right.
But let's face it, disagreements happen even with the best of intentions.
Oh, happens all the time.
So how do we navigate those tricky situations, where things go sideways?
Well, the good news is a well-written contract.
Okay.
That's your best defense against disputes.
I see.
It's like a roadmap that clearly outlines everyone's rights and responsibilities.
Right.
If you're ever unsure about something, just refer back to the contract.
Yeah.
It can often clear up the confusion.
That makes sense. It's like having a rule book for your collaboration.
Exactly.
But what if, despite everyone's best efforts, a conflict arises?
Yeah.
What are the steps, involved in resolving it?
Well, the first step is always to try to work things out directly with the other party.
Okay.
Open communication, clear explanations, and a willingness to compromise.
Right.
Those can often resolve misunderstandings before they escalate into something bigger.
Communication is key.
It is.
But what if talking it out doesn't lead to a resolution? What are our options then?
Well, if you can't reach an agreement on your own, bringing in a neutral mediator can be incredibly helpful.
Okay.
A mediator is a trained professional who can help facilitate a conversation,
Right.
identify common ground, and hopefully guide both parties towards a mutually agreeable solution.
So it's like having a referee to help keep things fair and objective.
Exactly. A mediator can bring a fresh perspective and help diffuse any tension or emotion that might be clouding the issue.
And then, of course, there's always the option of taking legal action.
As a last resort, yes.
That sounds like a stressful situation. Hopefully it never comes to that.
Hopefully not.
But it's good to know that there are legal avenues available if all else fails.
Absolutely. Now, let's shift gears a little bit and talk about a topic that's particularly relevant to our audience today.
All right.
Education.
Yes.
Ganakel has a whole section dedicated to the special considerations for copyright and educational content.
This is where things get really interesting for all you teachers and instructors out there. Educators are constantly creating valuable content.
Yes.
And it's crucial to understand how to protect their work.
Couldn't agree more. And because educational content is often shared and reused in various ways, it's essential to have a solid understanding of how copyright applies in this context.
So what are some of the key things educators need to know about copyright and their educational materials? What does Ganakel highlight?
Well, first and foremost, it's important to recognize that copyright protection applies to a wide range of educational content.
Okay.
We're talking about everything from written materials like textbooks, articles, and handouts, to multimedia resources like videos, audio recordings, and even software.
So it's not just about protecting the words on a page.
No.
It's about safeguarding all the different ways we express knowledge and ideas in the educational realm.
Exactly. And here's a key point that often trips people up.
Okay.
Copyright protection is automatic.
Right.
You don't have to register your work or go through any formal process.
Wow.
As soon as you create something original, boom, it's protected by copyright.
That's good to know. But I imagine things can get a little tricky when we're talking about collaboration and sharing in the educational context.
Right.
How does copyright work when multiple educators are working together on a project?
That's a great question.
Yeah.
And it highlights why it's so important to have clear agreements in place when multiple creators are involved, or when materials are being shared beyond the initial classroom setting.
So if I'm co-creating a curriculum with a colleague, we should have a written agreement that outlines who owns the copyright to what.
Absolutely. It's always best to clarify ownership upfront, to avoid any misunderstandings or disputes down the road.
Smart.
And this is especially relevant when it comes to something called works made for hire.
Works made for hire. That sounds kind of ominous.
Yeah, it's not as scary as it sounds. It basically refers to situations where someone creates work as part of their employment. Or under a contract.
Got it.
In these cases, the copyright typically belongs to the employer or the client, not the individual creator.
So if a school district hires me to develop a new math curriculum, the copyright to that curriculum might belong to the district, not to me.
That's right. It's always essential to understand the terms of your employment or contract to clarify who owns the copyright to the works you create. Sometimes you might retain some rights, but other times the copyright might be fully assigned to the employer.
Makes sense. Now, Ganakel also provides some specific guidance for educators who are considering, like, transferring or licensing their educational materials to others. This seems like a key issue in today's world where online learning platforms are so prevalent.
It is, and this is where it's crucial for educators to think carefully about their goals and how they want their work to be used. Are you comfortable with others modifying your materials? Do you want to retain the right to use them in other contexts?
So it's not just a black and white issue of giving away your copyright. There's a whole spectrum of options for how educators can share and control their work.
Exactly. You can choose to transfer all of your rights, grant specific licenses, or even retain all of your rights while allowing others to use your work under certain conditions.
Okay, so let's say I've created a fantastic online course on creative writing. And a publishing company wants to distribute it. What are some of the key things I should consider before signing any agreements?
Well, first and foremost, you need to be clear about what rights you're willing to grant. Are you giving them exclusive rights to distribute the course, or can you still offer it on your own platform?
I wouldn't want to sign away my rights and then be unable to use my own course.
Exactly. And then you need to think about the financial terms. Are you getting a flat fee, royalties, or a combination of both?
Yeah.
And how will those payments be structured?
Money matters. It's important for educators to get a fair deal for their hard work and expertise.
Absolutely. And then there are other factors to consider, like the duration of the agreement, the geographical scope, and any provisions for modifications or updates to the course.
Sounds like there's a lot to think about. But having this information from Ganakel is so empowering. It gives educators the knowledge they need to make informed decisions about their work.
Right.
And protect their intellectual property.
I couldn't agree more. And remember, even if you're not planning on transferring or licensing your materials, understanding copyright is still essential for protecting your work and ensuring you get credit for your creativity.
Solid advice. Speaking of credit and creativity, before we were talking about AI and its impact on copyright.
Oh, yeah.
Especially in the educational context. It's a hot topic right now.
It is.
And I'm sure our listeners are curious to hear more.
Definitely.
Ready to tackle that AI conundrum.
Let's do it. It's a fascinating and complex issue that's going to become increasingly relevant as AI plays a bigger role in education.
Wow, that AI discussion, I don't know about you, but it really opened up a whole new dimension to this copyright conversation.
It did. It really did. It's amazing how technology is kind of like forcing us to rethink some of these fundamental concepts of ownership and authorship, you know?
It really is.
Yes.
And I think it's a perfect example of why it's so important to stay informed about copyright.
Yes.
Especially for educators who are, I mean, they're really on the front lines of implementing these new technologies.
Absolutely. They're the ones in the trenches.
Ganakel emphasizes that knowledge is power.
Yep.
And I couldn't agree more.
I agree.
The more educators understand about copyright, the better equipped they'll be to protect their work, navigate collaborations, and just make informed decisions about using other people's materials.
It's about empowerment, really.
Yeah.
Giving educators the tools and the knowledge they need to, confidently navigate this complex landscape. And it's not just about the legalities.
Right.
It's about fostering a culture of respect.
Ooh, I like that.
For intellectual property in the educational community.
A culture of respect.
Yeah.
It's about recognizing the value of creative work, whether it's a teacher's meticulously crafted lesson plan or a student's original research project.
Absolutely. And that respect extends to the ethical use of AI as well, which is something we touched on earlier. We need to ensure that these tools are used in a way that enhances education, not undermines the creativity and originality of teachers and students.
So it's about finding that balance, right?
Yes.
Embracing the potential of AI,
Yeah.
but also safeguarding the human element in education.
Precisely. It's about using AI as a tool.
Yes.
To amplify human creativity, not replace it. And that requires, it requires thoughtful consideration, open dialogue, and a commitment to ethical practices.
Ganakel also reminds us that copyright is, it's constantly evolving.
Always changing, yeah.
What might be considered fair use today could be challenged tomorrow.
Right.
As technology advances and new forms of creative expression emerge.
It's a dynamic field for sure.
It is.
And that's why it's so important to, just stay curious, keep learning, and be willing to adapt as the legal landscape shifts.
So it's not about memorizing a set of rules. It's about cultivating an ongoing awareness of how copyright intersects with education, technology, and creativity.
Couldn't have said it better myself. It's about being engaged, informed, and proactive in shaping the future of intellectual property in education.
Well, I think we've covered a lot of ground in this deep dive, from the basics of copyright law to the, almost mind-boggling implications of AI. I think we've really explored some of the key considerations for educators in today's digital world.
We've definitely given our listeners a lot to think about.
Yes.
And hopefully we've inspired them to keep exploring these issues and advocating for a fair and equitable approach to copyright in education.
On that note, I think it's time to wrap up this deep dive. Thanks, everyone, for joining us on this journey. It's been quite the exploration of copyright and all its complexity.
It has been fascinating.
It really has. Until next time, keep those creative sparks flying. And remember, knowledge is power. And a well-informed educator, that's a force to be reckoned with.
Couldn't agree more. Stay curious out there, everyone.